Thank you everyone for joining. Now we have Mr. Ahmed Khan Bukti with us, along with the main speaker, Arshad Jatoi Saab. Sir, thank you very much for coming down. And this is the topic on criminal appeals, basically. And Arshad Jatoi would be speaking and addressing the issues that are being dealt with in practice regarding the criminal appeals and its procedure and the case laws that are being used as a theme for all this criminal appeal subject. So the thing would, this would be in a way that Mr. Arshad Jatoi would address and speak on the whole topic. And once he is completed at the end, 10 minutes or 15 minutes so would be given. So if there are any questions that need any of the audience wish to put forward, Mr. Jatoi, that you could write it down in the chat box and you could address them at the end. So now I wouldn't waste enough time and would put Mr. Jatoi on charge to address the topic and would speak on this issue today. Ji, Mr. Jatoi, there you go.
Let me share my screen first, then I will start. Yes, thank you very much for waiting. Today is our lecture. Our discussion is on appeals under the criminal law and its practice and procedure. The appeals are provided in the CRPC, which provides in chapter 7, provided in part 7 and chapter 21 of the CRPC, which start from section 404 to 431 CRPC. Chapter 21, the summary of section 404 CRPC to 431 CRPC. The summary of this section is that appeals, there would be, it deals with the appeals against the orders, appeal from sentence, cases in which appeal lies, no appeal lies, that is plead guilty convictions and sentences, appeals from the orders of the appellate acquittal, powers of appellate courts in disposing of appeals, judgments and appellate courts, suspension of sentences where bail is to be granted by the appellate court while pending the appeal of the appellant, and the arrest of the accused, if any, ordered by the appellate court in acquittal appeals, and abatement of appeals in case of appellant during pendency of appeals accused died. The same procedure, almost same procedure is provided under the Indian Code of Criminal Procedure 1973 that provides in the chapter 19 of the Indian Criminal Procedure Code, which start from section 372 to 394 of the code. The powers of is almost same, and there's no much difference. The right of appeal in criminal appeals, the right of appeal in criminal matters is not a natural right, is created by the statute and must be governed by the statute with the conformity which the offender is tried under section. For that, section 40, you can see the section 404 CRPC. The word appeal means the right of carrying a particular case of an inferior court to a superior court with a view to ascertain whether the judgment order passed by the trial court is sustainable or not. Right of appeal has to be specifically provided in a statute, and it cannot arise by an implication. The difference between appellate appellate and revisional jurisdiction. The appellate jurisdiction and revisional jurisdiction are two different subjects. Under the appellate jurisdiction, the entire case, including factual and legal aspect of the case, are to be reopened, whereas under the revisional jurisdiction, a limited scope is provided to the court to examine the judgment order passed by the lower court. The appellate courts under the CRPC. Under the scheme of criminal procedure courts, there are two appellate courts where appeal can be filed as a matter of right, that is Sessions Court and the High Court. Sentences up to 4 years passed by either magistrate court or assistant session judge, appeal will be filed before Sessions Court under section 408 CRPC. And if the trial proceeded by the Sessions Court, appeals will be filed before High Court under section 410 CRPC. There would be no bar, like there should be more than 4 years or less than uh, 4 years. If the sentence is even for 1 year, then appeal will be filed before High Court. The role of Supreme Court in criminal appeals will be discussed later in this meeting. Their separate procedure for filing an appeal the before the Honorable Supreme Court. I'm just giving the overview of all sections. Then we will discuss this whole issues like when we deal with the appeal cases. Therefore, you have to bear me for certain minutes. So, no, there is no appeal in certain matters where accused pleaded guilty while pending his trial. Against the plead guilty orders or judgment, there would be no appeal to the only except to the extent of question of sentence only. That was uh, that was also uh, decided by the uh, Honorable Sindh High Court in the case of reported at 1977 Karachi 1049, wherein it is held that the appeal can be filed against the plead guilty judgments orders to the extent of sentence, or where a high court had passed a sentence of imprisonment not exceeding 6 months and fine not exceeding 200 rupees. And when sessions judge pass a sentence not exceeding 1 month, or court of sessions or magistrate of first class passed a sentence pass a sentence not exceeding 50 rupees, there is bar. There would be no appeal against these orders. Or in a situation where appeal has been barred by any provision of any act or ordinance. Procedure of appeals against the death sentences, besides the powers provided under section 410 CRPC, the section 474 CRPC provides that death sentence shall not be executed unless it is confirmed by the High Court. That while hearing the appeal death sentences, the Sessions Court or any other special court has to make a reference under section 374 CRPC to the High Court for confirmation of death sentences or otherwise. While hearing the confirmation cases by the High Court, the High Court may annul or may confirm the death sentences. For that, High Court has to hear complete complete. High Court has to hear complete appeal. It's like same procedure like appeal. High Court has to reappraise the whole evidence regarding the factual as well as legal issues. If in the case of in a situation where if the appellant has not filed had not preferred an appeal against his death sentences, even the High Court has to look whole case and in a high court may also acquit the accused or may order for retrial or for record further evidence in it. The section 375 CRPC is a similar to section 428 CRPC, wherein during appeal in ordinary cases, the High Court may direct recording for further inquiry to be made by himself or by the trial court, or he may also take the evidence either by himself or by the trial court. This section 378 CRPC procedure also is similar to section 429 CRPC, wherein the difference of opinion comes between the two judges of the High Court. Then a referee judge will be appointed. Matter will be referred to a referee judge, and who will decide on his own whether the right of appeal also provided against the acquittal orders. It is provided in section 417 CRPC to the state, aggrieved person, and the complainant. We may see there is difference between aggrieved person and complainant. Aggrieved person can be a legal here, and complainant can be any person who has lodged the complaint or FIR. The acquittal appeal can only be filed before High Court. It cannot be filed before Sessions Court or Supreme Court directly, but it has to be filed before the High Court. The High Court and either accused was acquitted by the trial court originally where case was proceeded, or by the appellate court, that should be a sessions court, or if acquitted by the High Court, then it will go to a Supreme Court under section 185(3) CRPC of the Constitution. If the appellate court in cases of appeal against acquittal may order, High Court can order for custody of the accused, and he will be sent to prison, or appellate courts may also grant bail that is provided in section 427 CRPC with or without sureties. It is different from the section 426 CRPC where the sentence has to be suspended of the appellant who has been convicted by the trial court. The powers of appellate court, before going to this, the section 418 CRPC provides the appellate court that the appellate court will decide the matter on legal as well as factual issues. Before the appellate court, it is open for the appellate court to decide the legal as well factual controversies or issues in the appeal. And further, in section 420 CRPC, it provides appeals when the convict or prisoner is in jail. It has to be presented to the superintendent jail, who will forward the same along with the memo of petition as well as certified copy of the judgment impugned before the appellate court. This duty is on the superintendent prisons, who will forward the same, and the limitation, practically the limitation period will be over for the appellant or a convict when he presents his appeal before a superintendent. If any delay caused by the superintendent, it won't apply on the appellant. Even otherwise, in prisons rules, rule 90, it is also duty of the superintendent prisons to inform the appellant or to inform the convict regarding his right of appeal and if he failed to inform the appel from convict, then delay can be condoned regarding non-informing to the appellant by the superintendent. There are several case laws on this point, and that will be shared later. These powers of appellate court, which are provided under Section 423 CRPC, there is one special section regarding regarding the appeals can be dismissed summarily. That is Section 421 CRPC, wherein appeals can be dismissed summarily without going into the merits of its either legal or factual. In my whole practice, I have a 10 years of experience. I never seen any appeal has been dismissed summarily without discussing an appeal. Normally, in appellate courts, when appeal is to be filed, which should be memo of appeal, that is called petition of appeal, wherein we discuss the factual, we put facts as well as grounds can be based on the factual controversies. If there is a contradiction between the deposition of witnesses, or there are legal issues, jurisdictional issues, and a spare clause, and it has to be submitted along with the judgment, which is impugned along with the appeal. But it can be dismissed. But in my 10 years experience, I have never seen any appeal has been dismissed summarily. That is that is also provided in Section 421 CRPC. But when it has been admitted, normally it has to be admitted on first date of a hearing, and paper book may be ordered on the very day when appeal is admitted. The procedure of paper book, preparation of paper book is not provided under the CRPC, but it is provided in Chief Court Rules, Section 80, so Rule 81 of Chief Court Rules, wherein paper book has to be prepared, where it is start like charge, they keep charge on top, then deposition of prosecution witnesses, and its exhibits, annexures, which they have produced while recording their evidence, and then statement of the accused recorded under Section 342 CRPC, then the statement, if any, recorded by the accused convict under Section 340 subsection 2 of CRPC, and defense witnesses, if any. So after preparation of paper book, the appellate court has to hear the appeals. But normally in appeal against acquittal, they first hear full-fledged hearing regarding admissibility of appeal. They cannot admit the appeal on the first day. Like appeal against conviction, they admit on first date of hearing, and the order for paper book. With regard to the appeal against acquittal, they have to hear for whether it is the evidence is there which for which the appeal has to be admitted. If the appellate court had admitted the appeal, then it will be heard and decided on both the legal issues, and court will reappraise the whole case. Appellate The appellate court, in cases of appeal against acquittal, that is provided powers in Section 423 CRPC. The appellate court against the acquittal judgment may reverse such order or direct further inquiry or retrial of the accused. First condition, that appellate court, that is high court, in appeal against acquittal, to reverse, high court can reverse the order or direct further inquiry or retrial of the accused, or send for trial to the Court of Sessions or High Court, as the case may be, or find the accused guilty and pass sentence on him. The High Court has power to convert the acquittal of the accused into conviction, which is provided in the Section 420 CRPC, before convicting the appellant under Section 423 CRPC by the High Court. High Court has to issue a show cause notice as to why not the conviction or why not acquittal of the accused has to be converted into conviction. After hearing the evidence, the high court without sending back the case to the trial court. In a from the the powers are almost same where the high court can reverse. It can be high court or sessions court. It's not necessary. Uh, it is not necessary that appeal has to be here by the uh, high court. It can be sessions court if the sentence is up to 4 years and it is passed by the magistrate or assistant session judge. And if the sentence is more than 4 years, the appeal will lie to high court under section 410408 CRPC. The High Court or the Sessions Court reverse the findings and sentence accused or discharge the accused or order him to be retried by a competent court of law or sent for trial, alter the finding, maintaining the sentence with or without such reduction, alter the nature of sentence subject to provision of section 73, not so as to enhance the same. The enhancement can only be made in the under jurisdiction, either sessions court or high court. The appellate court for the mostly we see the along with the appeal, the complainant, state or any aggrieved person files appeal. They file a revision for enhancement of sentence. They cannot be for enhancement. There there would be there is no appeal regarding if the sentence if the convict has been awarded a lesser sentence, the aggrieved person, state or complainant cannot file appeal for enhancement. For that, they have to file a review. In appeal, the appellate court may alter in order or reverse such order, and it may make the enhanced amendment or consequential or identity as may deem fit or proper. The appellate court, the appellate court may take further evidence if it thinks additional evidence to be necessary. The appeal may record reasons. That power is provided under section 420 CRPC, but it should not be fill in the lacuna. It should be for just decision of the case. Otherwise, if while hearing the appeal by a divisional bench of high court, if there is a difference arises between the two judges regarding the conviction or a sentence of the appellant, they will refer the matter to a referee judge. Normally, a referee judge has to be appointed by a chief justice of the high court. The powers are provided in section 429 of the CRPC. The referee judge will hear whole case and not just a point of difference which is referred to him. This is a very disputed point wherein there are several judgments. There are some judgments which says the referee judge only appointed to resolve the point of controversy. He cannot go beyond that controversy. Like if the one judge accused appellant and other has convicted him, then referee just has to concur anyone. Like either he convict the appellant or he convict the it is held the Honorable Dhaka High Court that will hear and not just point of controversy. So the referee judge authorized has all powers to hear the one judge was earlier convicted him for life sentence or death sentence, he can give him lesser punishment. And this after deciding this referee deciding by the if the referee judge had decided the point on his own or he gave his own opinion, that would be final, and a judgment will follow that opinion. Appeals, we have the deposition of witnesses. We mostly see between deposition of eyewitnesses, like witness to witnesses means one witness contradict to other witnesses, or circumstantial, or but and contradiction. It should be main point. If it is a murder case, one witness saying he is killed by the one person who was holding a gun, and the other witness is saying yes, he was holding gun, but he was wearing like he was holding gun with the right hand or left hand, or he was holding gun by on head of the accused or head of the deceased, or these should not be these contradictions are not considered by the appellate courts, but contradiction should be material, like in contradiction should be material, like if the one witness is saying that the deceased killed by the accused with a shotgun or any gun or a pistol, then other witness say he was killed by through hatchet or anything else, or other weapon which is totally different from alleged by the uh, other witness. And in the if the evidence is if the medical evidence contradicts the ocular evidence, then preference will be given to a medical evidence, because a document or expert is an independent witness and he cannot lie for that point. If the medical evidence is saying that disease was killed through a firearm injury which was caused by by a gun, which pellet injuries, and the witnesses are saying the deceased was murdered through a pistol, there's one bullet, then the preference will be given to medical evidence. In this point, there are several judgments which says the preference will be given to ocular evidence, but the most of the judgments and correct view, as per my point of view, is that the uh, preference will be given to medical evidence, because it's a documentary evidence and expert is an independent person, gives his evidence on injuries seen by him on the deceased. So also, if the prosecution had examined the witnesses or any other evidence, recorded any other evidence, it has to be confronted to the accused in his 342 CRP statement. Otherwise, it will not be considered as an evidence against the appellant or convict. In the very recent judgment, this Honorable High Court of Sindh, which is reported as 2020 PCRLJ 1693, the Honorable High Court of Sindh held that if there is a material contradictions existed between the evidence of prosecuting witnesses in a situation where witness contradict the version of other prosecuting or so circumstantial adduced by the prosecution. The example is medical evidence, medical certificate contradicts seat of injuries on the body of the deceased or weapon used in crime, etc. Then appellant will be acquitted on this ground, or if in 342 statement, if no incriminating evidence put to the accused that cannot be relied upon, and appellate court cannot just material was not asked in 342 CRPC statement. This issue was normally the appellate courts when they uh, see that the when they read out 340 statements of the accused, when they didn't see the trial court failed to ask incriminating evidence against the appellant in his statement, then they remand the appeal for uh, recording of 342 statement, where the leftover material will be asked to the appellant in his 342 step. In this judgment, the Honorable High Court had discouraged this view, and the Honorable High Court held that the matter will not be remanded back for just to fill in the lacuna of the prosecution case, or if the trial court failed to confront the evidence and it cannot be remanded. This view was taken by a high court from the judgment reported in 2010 SCMR 1009. And there is another report, there is an unreported judgment where I won't share on this screen, but that case was our office case, and the it was heard by the Honorable Chief Justice and Mr. Khosa, Asif Said Khosa. He specifically held in that case with regarding for recording of three-party for purpose of recording fresh 342 cannot be remanded, and it would be unjust with the accused to fill lacuna against him. But there is another Supreme judgment which says uh, this is regarding the contradiction between ocular medical as well as ocular evidence that is reported as 2011 SCMR 323. In this judgment, the Honorable Supreme Court has also acquitted the accused persons who had not filed appeals before the Supreme Court, even before the High Court. The appellate court has all powers if one of the accused had filed, if there are more than one accused and one accused has filed the appeal and other has not filed, then the person who has not filed the appeal, he can also be acquitted by the appellate court after seeing uh, look into the meta evidence of the prosecution. This is very important judgment, 2011 SCMR 323. There is appeals from the powers is provided. Appeal is provided from the special courts orders. There are several special courts. They have a different time limits for filing of appeals before the High Court, and it will be heard and decided by the divisional bench in most of the cases, because in appeals against the special court like prevention of corruption court, the appeal will go to a single judge, but in most of the special courts judgments, the appeal will go to a divisional bench of the High Court. As in the offenses in Banks Ordinance 1984, appeal is provided in section 10.1 of the ordinance, which provides the appellant to appeal to the High Court within whose jurisdiction the sentence has been passed. The time is provided 30 days, limitation is provided 30 days, which will be heard and decided by two judges of the Honorable Court. Appeal under CNS Act, that also Section 48 of the CNS provides that the appeal will lie to High Court and shall be decided bench not less than two judges, and the limitation is 30 days, same 30 days. Appeal under the ATA 1997. That provides appeals provided under Section 25 of the Act will appeal will lie to High Court, and the record of the trial proceedings shall be transmitted to High Court within 3 days of the decision. In this case, the appellant may file appeal within 15 days. The here limitation is 15 days. If the ATA judge had convicted the convict, then for death sentence, he has to file appeal against the death sentence within 7 days. For that, and appeals under the LAP ordinance that is provided in Section 32 of the ordinance, and whose appeal will be filed 10 days, and it will be heard and decided by a bench not less than two judges. These are few judgments wherein the Honorable High Court and Supreme Court held that there are certain these are the certain points wherein the appellate courts had acquitted the accused persons, even prosecution has successfully proved their case. In a case where the prosecution has concealed the injuries on the part of the deceased or on part of the convict or accused. In this scenario, the Honorable Apex Court in the Amjad case held that if the prosecution is not truthful with regard to the case, with regard to the injuries to the accused, then they cannot be relied, and it will create doubt and also in prosecution case. There are other several judgments on if there is a improper identification parades, and it is for when we have to discuss first when identification parades to be held. Identification parades has to be held where the accused persons are not named in FIR, their identity is doubtful, then identification is mandatory and necessary. When accused, and it is also mandatory for the witnesses while they are identifying the accused persons in identification parade, they have to give their specific role. If they don't give a specific role against the accused person, then identification parade will not be relied, as it was held in the judgment 2020 MLD 1996. Even if the identification parade has been held jointly with more than one accused persons, then identification will not be relied upon. And there is a very recent judgment wherein the identification guidelines provided, that is PLD 2019 Supreme Court 484. But it is mandatory for it is like the trial advocate who should be vigilant, and who also confront these lacunas to the witnesses who comes to give evidence against the accused in during recording of the evidence. Even if the learned trial advocate is not asking questions regarding improper identification parade or conviction or confessions or any other evidence, then still court has to look into the improper identification parades or confessions. For this, the judgment is 2000 PLD 2019 Supreme Court 484. There is another principle that is false in uno, false in omnibus, false in one thing, false in everything. Before this judgment, which is reported as PLD 2019 Supreme Court 527, it was it was time and again held by appellate courts that this principle is not applicable in every case. Means this principle can the court can sift grain from chaff is they has appellate court has to see, or even trial court has to see that if the prosecution witness is giving evidence against one accused and they are finding him truthful against that accused, and with regard to other accused persons, remaining accused persons, a witness is not giving truthful evidence or is not reposing truthful truth, then the against whom he gave truthful evidence or confidence inspiring evidence, then the court may convict him. But in this judgment, the Honorable Apex Court held that if a person is lying on one thing, one set of facts, or accused person, he can lie on other set of facts and accused person. And through this judgment, other uh, all other principles that was like sift grain from chaff, it was disapproved, and it cannot be relied anymore while hearing while deciding the cases of the accused persons. If the its principle is very simple and it is within the guidelines as per our Sharia law as well. The appeal evidence of audio video under Article 164 of Qanun Shahada 1984. There is also guidelines provided in judgment reported in Ishtiaq Ahmed Mirza case PLD 2019 Supreme Court 675. There are several guidelines when the audio video evidence is produced by the prosecution. In this judgment, there are certain guidelines, but it is important to mention it is duty of the trial judge while admitting these kind of evidences, like court has to see the evidence should be fall within the provision of PFSA 2007, and evidence accuracy of evidence must be proved without any possibility of tampering. Evidence must be actual record of the evidence. A person who recorded such audio or video has to be produced before the trial court himself, and that audio video must be played in the court, and it to be and ought to be audible and viewable in case of video. Person recording the evidence must identify the voice of person, and same be produced by himself, must be played in the court. Person recording the evidence must identify voice or voice person seen in evidence. Independent witness be required to testify recording of evidence. In these if any of these guidelines is not fulfilled by the prosecution, then the audio video evidence will not be relied for convicting the accused. There are powers to the appellate courts that appellate courts means sessions court as well as high court, to suspend the sentence of the appellants, which is provided under section 426 CRPC, and a convict appellant may be released on the bail on the surety or without surety. But there is a one judgment of Honorable Apex Court uh, in 2012 SCMR page 997. The Honorable Apex Court held that it is not necessary for the appellant should be in jail, then he may apply for suspension of his sentence. This is it was very controversial issue because there are several judgments which interpret that for releasing the appellant on bail and suspending his sentence, then appellant should be in jail. But the Honorable Apex Court in their judgment, uh, 2012 SCMR 997, held that the appellant can be granted bail and his sentence can be suspended even he is not in jail and he is before the appellate court. The evidence of DNA, it is also in very recent judgment, the Honorable Apex Court has given the guidelines that is reported in case PLD 2021 S S Supreme Court 362. The Honorable Apex Court has set out the uh, guidelines for regarding the DNA evidence, which is to be considered as a DNA evidence is considered as a golden established to identify an accused. DNA test due its accuracy and inclusion is one of the strongest corroborative evidence in sexual offense cases. Extent where to be which the judges could give to DNA report procedure for extracting DNA evidence is given the disjudgment issues related with the consent of the victim and its admissibility and admissibility of uh, DNA, evidence of DNA. This is also a issue in the narcotics cases, wherein the anti-narcotics force did not record the evidence of the person who who uh, uh, to whom the custody of the narcotics is given, like Malkhana in charge and the person who takes the sample from Malkhana to the forensic. Then this case, the Zubair Khan case 2021 SCMR, the Honorable Apex Court held that if there is prosecution fails to establish the safe custody and transmission of samples of narcotics from police to the chemical examiner, it cannot be relied upon and accused appellant will be acquitted on this ground only. This was specifically held in the following judgment, which is I have wrote down in my slide, that is 2019 ACMR 608, 2019 ACMR 1217, 2019 ACMR 2004. The Honorable Apex Court in these judgments held that the person who's a Malkhana in charge has to be produced before the court and he has to be give his evidence regarding the safe custody of the narcotics, and he will be cross-examined by the counsel or by the pleader of the accused or accused himself, and the person and and a person who also takes the samples from the Malkhana in charge and hand over to the chemical examiner, he will also be produced before the court. Otherwise, it cannot be relied upon the evidence of this. The other issue, like confessional statements being recorded by magistrate through illegal means. We see in most of the appeal cases, in appeals, the trial courts convict the appellant on inadmissible confessions, and they have not followed the procedure as provided under the CRPC, that is section 164 CRPC and 364 CRPC, and the guidelines issued by the Honorable Apex Court. The one most important thing in recording the confessional statement of the accused person, it is necessary for the magistrate before recording the confession of the accused, he has to inform the accused that that if he records his confessional statement, he can be convicted on this confessional statement solely. And if he doesn't record the confessional statement, then he will not given custody to the police, IO, mostly we call it IO. His custody will be given to the jail authorities. He will taken into judicial custody. We call it judicial custody. This is the very important, because most of the accused persons who record their confessions, they record on this because of this fear that if they don't record their confessional statement as the police have told them, then they, if they are not going back, if they are going back to with police, they could torture them and they could kill them or do anything. But if the magistrate is informing him, informing the convict that his custody will not be, his custody will not given to the uh, police, and he will be taken into judicial custody, he may not record confessions. But there are certain guidelines which is provided in the Ismail case, which is reported in 2017 SCMR 713, which is those are that the accused must be in his full senses and understand the consequences of making a confession. Confession should not be result of any duress, coercion, or any promise. And trial court has to check while transit of the accused for each peshi appearance. This means then after how many peshes the accused, after how many peshes or remand or court hearing, the accused is confessing before them. This is also important factor, because if a guilty person thinks that he had committed an offense and his conscience is telling him to confess the offense, he he could have uh, uh, could have agreed on the first date of hearing or second date of hearing. If he's agreeing on like fourth or fifth peshi or his appearance before the court, then court may refuse to record uh, his confession, and it could be on any pressure or threat. And actual facts should be determined, which induced the accused to confess after facing trial, during which they plead guilty or in all the way. In these situations, that accused has to be trial court has to inform the accused if he has given any inducement, or if they given anything, like they will leave him, left him with the case. If he record his confession, then he won't be released on the promise of police, but court can convict him on his confession. For confession, it is necessary, it's mandatory for the trial court that before recording confession, there should accused must have given a reflection time of reflection, where where the trial court or magistrate asks the police to leave the court and other staff, and he may be the accused may be allowed to consult with his counsel regarding his regarding uh, he should confess or not. This point is also necessary for the magistrate to give the accused opportunity, if it is necessary, to consult with his counsel before recording the confession. And there are certain other things, like his handcuffs should be removed and provided a chair and dice. Dice is like is a accused, where accused stands. The trial judge should explain the accused that in case of making confession, the accused has to suffer capital sentence in a murder case or any offense punishable with death. And the confession should be inculpatory. That is also very important fact. If the confession is not uh, if the confession is not inculpatory. If it is expiatory, it cannot be relied upon. In a case like if a accused is saying, I went with my friend, there are two accused persons and they are involved in one crime, and the one accused is saying he just went because he was a friend and he doesn't know regarding that what the other friend will do. Means his intention was like going for having a tea, but when they reach the place of incident and other friend has killed someone, then they this confessional statement won't be relied by the trial courts or appellate courts, because confessions should be uh, inculpatory, wherein the accused has to show his role. Like he should tell the court or magistrate or the trial court that they went to commit a crime, if they went for regarding this, and it should be, he should be involving himself, not just co-accused. If if the above if these conditions have not been fulfilled, then the appellate court can acquit the accused on this point only. The appeals before the Supreme Court. The appeals are provided to the Supreme Court, that is Article 185 of the Constitution, which provides the appellate jurisdiction of the Supreme Court against the judgments, decrees, final orders, or sentences of High Court. There is a condition for filing of appeal before the Supreme Court. The limitation period for filing of appeal before the Supreme Court is 30 days. And before filing appeal before the Supreme Court, the appellant or petitioner, whom you may call him either petitioner or the appellant, he has to seek court leave of the court to file appeal before the Supreme Court. There are several grounds on which the appellant could seek the leave to appeal, but the main ground for seeking a special leave to appeal is uh, there is a substantial question of law or public importance is involved. Otherwise, leave to appeal, even in cases of death sentences or life imprisonment cases, cannot be granted if there is a no question of no substantial question of law of public importance is involved. Now, I will share my experience regarding hearing of appeals before the High Court or Sessions Court. In appeals before the High Court appeal, I'm talking about most regarding the appeals against convictions. The appeal against convictions, in appeal against convictions, the High Court, on the first date of hearing, when appeal comes before a court, then they admits the appeal and they order for preparation of paper book. The preparation of paper book is, as I already told you, that it's not provided under the CRPC, but it comes from the Chief Court rules. Since Chief Court rules, it's Rule 81, wherein the RMP of the trial court has called, it should be called from the trial court, and paper book is to be prepared. And in paper book, mostly they separate the case diaries or miscellaneous papers in first part. In the second part, they put charge, deposition of witnesses, and their exhibits. If they are not in English, then the criminal branch of the High Court or Sessions Court will translate into English. This is mandatory, because several judges, while hearing the appeal, don't understand either it's in Sindhi or in Urdu, because police always write in typical Urdu or in typical Sindhi, which is not easy to read. For this, there is a translation branch in High Court, in every High Court, which translate. That is also provided in the Chief Court rules, and they translate into English, and they put with the original. They annex with the original one. Uh, this before, uh, I think in 80s or 70s, when when the appellate court order for preparation of paper book, the uh, the copying branch of the High Court has to type every page of the RMP. If it is not in Sindhi or if it is not in English, they make English of it. And nowadays, what they do, they just copy the original and make the paper book, and they sometimes translate, sometimes they does not, sometimes they don't translate it, but most of the cases they translate. When we start arguing appeal, uh, there are different benches have different attitudes. Some benches ask the lawyers that he should give us give them summary of a case. Means he has to inform the basics of the case, like if there is a contradiction, if there is a delay in FIR, or there are legal issues like the confessions have been not recorded as per law, or the evidence has been admitted without following the procedure. But there are some benches which they ask the uh, lawyer to read out whole evidence from the charge to till 342 statement or defense witnesses. Then they give a chance to argue a case, but they won't let a lawyer uh, counsel to clarify the lacunas of the prosecution evidence while he is reading the paper. Because that is necessary when in some appeals, there are sometimes there's a 50 PWs, and one PW contradict the other. If the PW1 is the PW10 is contradicting PW1, then if the lawyer if not allowed to clarify or inform the court that this PW10 is contradicting the evidence of the PW1, then at the when the court is hearing the reading the evidence of PW10 or PW50, and after hearing the 342 statement, they cannot recall. It's humanly not possible for them to recall that there was a contradiction between PW1 and 10. But uh, if it is not if it was not allowed to explain by the lawyer, then it is necessary, uh, while arguing the appeal, the counsel has to inform, has to clarify every piece of evidence to the bench that this is the lacuna and this is contradicting the evidence of the one witness to other witness while reading the evidence, not afterwards after uh, reading the whole paper book and 342 statement of the accused persons. And mostly appeals, the uh, in most appeals, the the lawyers has to see the even in trials, he has to they have to see the if there is a delay in FIR or name of accused persons are mentioned in FIR or not, or they have they uh, they uh, a specific role has been assigned to them or not, or the statement of witnesses were recording with delay or not, and their delay is explained by them in their statements or not. If they if they have made improvements in their case, like they are not assigning their role in their statements, and while they are depositing in court, and they are assigning the role to the to the accused, uh, then the lawyers who are defending them in trials must confront their improvements to them, because it is necessary. If anything is not asked in cross examination, that cannot be, that must be admitted by the accused, that is the principle. And mostly the uh, high court or the appellate, any appellate court, that is that can be sessions court, uh, they they will say that if this was not though the witnesses had improved their statements in court, but it was not cross examined by the defense, then it should be relied their statements. uh, I think I have concluded my like my meeting, my experience. Now you may ask questions if anything is ambiguous. Mostly you people are lawyers, know and dealt appeals. Uh, but I'm ready to give answer if there is any question or thing.
I think there is one question, Mr. Jatoi, in the chat box by Sirat Fatma. If you could look into it.
Yes,
If you could turn your chat box on, you would see there is one question.
yes, it's a very good question. That so when you say that DNA evidence is gold standard, what do you mean by it? Since the forensic experts who work closely with judicial abroad along flag posts in the DNA profiles or as a continuation of discriminations, so how we deal such a matter in their district. The Honorable Apex Court, which in this judgment, which is reported in 2021, as I discussed earlier, they held that this evidence is a gold standard. It means this evidence is very vital when they are deciding the cases like where where DNA evidence is adduced by the prosecution. It means it connects the accused uh, directly with the victim, because if the samples matches in Pakistan, there is a laboratory, a forensic laboratory in Lahore, which the give evidence of, like they prepare, they take profiles of DNA and give conclusive reports. With they have a standard of international level, or but that this evidence is like it's a direct evidence, direct connect, though it's not a though it's not a ocular evidence, though it's not a evidence of eyewitness, but it connects the accused directly with the crime.
For me, there's a lecture going on and you're saying Mama Magga. How would you feel? It's not a nice thing, better you can wait. I don't have a Magga.
Yes.
He's been dealt with. Sorry for the interruption. Mr.
Yes,
Jatoi, if your slides are
Another
over.
question.
There is one question, it's just in my head, that is what is the provision with regarding clubbing two cases, one at the trial court and the other in the high court level? What does the CRPC tells about that? That how could you get it clubbed in the high court?
No, High Court don't collect the matter of trial court into proceedings of the appeals. They call RMPs. From RMP, it is a record and proceedings of the trial court. And under the chief court rules, they order for preparation of paper book from these RMPs. Means they bifurcate these RMPs in two parts. One is miscellaneous part, other is material part. In material part, they take out the uh, charge, deposition of witnesses, 342 statement, and evidence of defense witnesses, if any. This appeals, the preparation of paper book is like it should be serial wise. Like they keep charge, then deposition of witnesses along with their exhibits, 342 statement, 340 subsection 2 CRPC statement, if any there, or defense witnesses, then judgment of the trial court, then memo of appeal, means petition of appeal.
Thank you. I think that is it. There was no other question as of now, as we would see.
Sir, I have one question.
Sure, Kosa sir, please.
It's regarding section 428.
Jatoi sir,
Okay,
could
what's
you hear him?
Additional evidence.
Yes.
What are the conditions where the court entertain or admits the additional evidence?
So additional
appeal.
evidence. Yes, I'm replying. The additional evidence only be recorded where it is necessary for just decision of the case. That is the only criteria given in the section 428 CRPC, or anything left by the trial court or prosecution, which was necessary for deciding the case. I can give you a judgment of the Supreme Court on this that say that it should be for just decision of the case, not otherwise.
Thank you, sir.
Thank you.
So, anyone else, if seeks to get his question answered by Mr. Jatoi? I think that is it, pretty much. And thank you everyone for joining in. And those who have joined us, I'm very grateful for them. I think I could see Mr. Shahid Qureshi video.
One question.
Sir, please. Mr. Jatoi, could you hear Mr. Shahid?
Yes.
Actually, we know about that. You both of you are senior lawyers, no doubt about that. I've also been
Not as much as
practicing
you are.
criminal. My question is, I mean, just for the young ones who are watching this conference, whether an appeal can be filed before a district judge or a high court or before the Supreme Court of Pakistan on behalf of an absconder. You know about it, we know about it, but for the students who are watching this, I think you should clarify this point.
Yes, sir, that is very important question. And no appeal can be filed any of the court, either it's a sessions court or high court or Supreme Court by an absconder, until and unless. But there is a condition which I refer the judgment 2012 SCMR 997, which says if the appellant has been convicted by the trial court, but he has not surrendered before the trial court, he can approach high court and file an appeal, and he can request for his suspension of sentence. Then the suspension of sentence, this surrender would be deemed to be a surrender before a trial court who convicted. But otherwise, it's a settled law. No appeal would be entertained. No appeal can be filed by an absconder.
Yeah. Thank you.
Thank you.
Well, Mr. Jatoi, I think that is it pretty much. And thank you for your time, everyone. And thank you, Jatoi Saab, for giving your time. And we'll hope to see you all again some other time with some other discussion that we will have in future. So till then, take care. Thank you very much. Everyone take care.
Thank you.
Allah Hafiz.
Thank you.